Hear ye, hear ye, hear ye. All manner of persons having anything to bring before the honorable justices of the Supreme Court of the state of Delaware will now draw near and give their attendance. The court is now open. God save the state and the honorable court. Please be seated.
Good morning, Counsel. Good morning, Mr. Barlow.
Your Honor, good morning. May it please the court. Mike Barlow from Abrams and Bayless. I'm here today to introduce our counsel on the appellee side, Mr. Mike Karlinski from the Quinn Emanuel firm, and Mr. Chris Landau from the Quinn Emanuel firm. Here today on behalf of Crestview Oxbow Acquisition and Crestview Oxbow Orissa Acquisition. Mr. Karlinski will be presenting the argument with the permission of the court, and he'll also be presenting argument on behalf of Loadline Capital, represented today by Mr. Clay Athey and by his co-counsel from the Seward firm, Mr. Dale Christensen and Mr. Mike Whiteman.
Welcome, everyone. Thank you, Mr. Barlow. Morning, Mr. Norman.
Good morning, Your Honors. Steve Norman on behalf of the Koch parties. I'm here to introduce my co-counsel, David Hennis and Thomas Brown from the firm of Ropes and Gray.
Welcome.
And with Your Honor's permission, Mr. Hennis is going to make the argument on behalf of the Koch parties.
Thank you, Mr.
Thank you,
Norman.
Your Honor.
Your Honors, may it please the Court, David Hennis from Ropes and Gray on behalf of the Koch parties. This is a simple case of contract interpretation involving a Delaware LLC agreement negotiated and executed by sophisticated parties advised by preeminent counsel. The court below twice found that the plain language of the LLC agreement prohibited an exit sale from going forward because the contractually required price floor could not be met under then current conditions. The Vice Chancellor correctly held that the plain language of the LLC agreement prohibits the payment of a top-off to the small holders to satisfy the 1.5 times return requirement and avoid the contractual price floor. That conclusion disposes of both of the bases on which the minority members defend the Vice Chancellor's post-trial decision, which should be reversed. First, the plain language of the agreement refutes the minority members' newly minted argument that the LLC agreement affirmatively permits a top-off to force an exit sale. Second, because the Vice Chancellor found that a top-off was foreclosed, controlling Delaware law prohibited the court from using the implied covenant to blue pencil the agreement to add that exact term. At the same time, the Vice Chancellor eliminated the equal treatment requirements for all members, rights which the trial court also found were plain on the face of the agreement. The implied covenant here, Your Honors, was also foreclosed by the Vice Chancellor's finding that Mr. Koch considered a top-off to be a deal killer in the parties' original negotiating positions in 2007. In an attempt to sidestep those clear conclusions, the Vice Chancellor made another error. This court's precedents make clear that an implied covenant analysis must focus on the time of contracting, which was 2007 here, when the members negotiated and executed the LLC agreement. But instead, the Vice Chancellor improperly focused his analysis on the events of 2011, when the smallholders were admitted as members of Oxbow. This was error because the smallholder admission was an act by the Oxbow board carrying out its authority under the 07 LLC agreement. The existing members of Oxbow, who are parties to the LLC agreement, did not negotiate or execute any new agreements in 2011, nor did those members negotiate or execute any amendments to the existing LLC agreement in 2011. And nor did they need to. There was no gap in the LLC agreement regarding member admission. For these reasons, the court should reverse the Vice Chancellor's post-trial decisions. And Your Honor, this morning, I'd like to first turn to what the court found below as to the plain meaning of the contract, then address the minority members' new theory, and then finally address the implied covenant holding. Your Honors, first, turning to the highest amount theory. As I mentioned, the Vice Chancellor found that the highest amount theory was mandated by the plain language of the LLC agreement. He made that finding twice, following an early summary judgment hearing and again post-trial. The highest amount theory stems from the LLC agreement's clear requirements that, first, all members receive at least 1.5 times their capital contributions from an exit sale, taking into account proceeds from a sale to a third party and prior distributions from Oxbow. And second, all members must receive the same exit sale consideration because of the two equal treatment requirements in the LLC agreement, including the same terms and conditions requirement. Thus, under the highest amount theory, the member with the highest required sale price to reach a 1.5 times return sets the floor price for all members in an exit sale. The Vice Chancellor expressly found that the highest amount theory was the only reasonable interpretation of the LLC agreement. The Vice Chancellor also found that extrinsic evidence should not be considered because the contract was unambiguous. At every stage of the litigation, the minority members have argued and agreed that the contract was unambiguous. The Vice Chancellor nonetheless considered the extrinsic evidence and found that, if considered, that extrinsic evidence would not change the proper interpretation of the highest amount theory. That plain language finding should have ended the litigation either on summary judgment or post-trial. So, Your Honors, that takes us to the minority members' newest interpretation of the LLC agreement, which is that it affirmatively permits the payment by them of a top-off in order to force an exit sale. This argument fails as a matter of contract, but as an initial matter, the minority members cannot meet Rule 8's requirement to show that the argument was fairly presented below. That's because they never argued below that the plain language of the LLC agreement affirmatively permits a top-off payment. That's because it doesn't. Instead, before the Vice Chancellor, the minority members took the exact opposite position of the one they're taking in this court. In arguing for the implied covenant, Your Honors, the minority members claimed that the LLC agreement contained a gap because it did not expressly permit or prohibit a top-off. That was their pre- and post-trial position. Under this court's decision in Nationwide, Rule 8 cannot be met when, quote, for much of trial, close quote, the party argued the opposite position below. That's 122A3rd at 892. Here, of course, Your Honors, the minority members argued the opposite position for their entire case. So the minority members' new theory should be rejected in the first instance for failure to comply with Rule 8. Your Honors, we would submit that the reason the plain language top-off argument was never presented below by the minority members is because it's wrong. As an initial matter, there's no term in the agreement that affirmatively authorizes a top-off payment. Indeed, the minority members point to no language in the agreement that requires the members to accept the top-off, as they argue. And the top-off would violate at least 3 clear provisions of the LLC agreement, as the Vice Chancellor found. First, as I mentioned, the only funds that count under the contract to reach the 1.5 times thresholds are prior distributions made by Oxbow and the resulting proceeds from an exit sale. They try to end run these clear terms by arguing that resulting proceeds don't have to come from a buyer. But the proceeds that count must be the ones resulting from an exit sale, the definition of which means a transfer of all but not less than all of Oxbow's units to an arm's-length buyer in a bona fide transaction. The definition of exit sale does not encompass a separate transaction, separate side transaction. Second, Your Honors, even if the separate side payment were considered resulting proceeds, it would violate the LLC agreement's 2 equal treatment requirements, as I mentioned. The agreement requires that all units transferred in an exit sale shall be transferred on the same terms and conditions as each other unit so transferred. Making a top-off payment to the smallholders would violate the same terms and conditions requirement by definition. One set of members receives greater consideration, the extra payment, the side payment, than other members. Those are different terms. The agreement also requires that exit sale proceeds be distributed pro rata due to the percentage interest provision of the LLC agreements. This means that exit sale proceeds must be distributed to all unit holders in proportion to the number of units held, as the Vice Chancellor found. Of course, for the same reason as same terms and conditions, a separate side payment means that exit sale proceeds will not be distributed pro rata, since some members will get a higher proportion than their units held. In sum, the Vice Chancellor correctly held that these provisions, quote, foreclose a top-off option, close quote, because sale proceeds would be reallocated so that the smallholders receive more than their pro rata share. So, Your Honors, we submit that the plain language is why the minority members never made this argument at any point before this appeal. Your Honors, turning to the implied covenant holding. In reaching the result here, we respectfully submit that the Vice Chancellor recognized, but then violated, nearly every principle governing the implied covenant established by this court. In Nationwide, this court stated that when a buyer and seller negotiate a detailed contract, Delaware law requires that the contract's express terms be honored and prevents a party from using the implied covenant of good faith and fair dealing to obtain in court what it could not get at the bargaining table. That's 122A3rd at 881. It is particularly inappropriate to base an implied covenant holding on the court's stated view of fairness, as the Vice Chancellor did here. As the Chief Justice, then Chancellor, explained in Aruga versus Gatz, a generalized fairness inquiry under the guise of an implied covenant review is an invitation to inject unpredictability into both entity and contract law. That's 40A3rd at 854. The minority members are left to rely on the Vice Chancellor's improper time shifting, in which the Vice Chancellor focused not on the time the LLC agreement was actually negotiated and signed in 07, but instead on the 2011 smallholder admission. The reason, Your Honors, that the trial court and the minority members sidestepped the 07 agreement is that the terms of that contract prohibit some members from receiving more consideration than other members in an exit sale, as I just mentioned. That's same terms and condition and pro rata distribution. As this court has repeatedly held, the implied covenant is not a means to override the express provisions of the contract. That is Nationwide, that is Nemec, that is bedrock Delaware law.
But what do we do when the parties didn't think to do something under the agreement? Isn't that a gap?
No, Your Honor, I would respectfully submit that there was no gap in 2011 because the issue of what happens to new members is covered by the 2007 agreement. There is a process for it. And then in 2011, what happens is if the board does not take action to vary the rights of new members, then those members have the same rights as other members. So it's clear by the operation of the agreement that there is no gap at that point in time.
But isn't it clear from this record that when they were admitted, they just didn't think to figure out the details of what that meant?
I would say the answer to that respectfully is no, Your Honor. The factual record is clear that the minority members received a memo which detailed and said that the new members were being admitted as members holding the same class of units as existing members. Then the board passed 2 resolutions admitting them using those terms that were in the memo, which is the same as members holding the same class of all other members at that current.
That's saying something that was already a given. They're subject to the terms of the LLC agreement. But there were additional terms and conditions that were being imposed. What's the price? Things like that. But weren't there other things that they just didn't think of, the permutations of admitting these new members and how it impacted the exit sale right?
Your Honor, the fact that the board only varied the price in this situation. The board, when it admitted both members, it set a price of $300 per unit, meant that it was to admit those members on the same terms as all other members. That is the operation of the agreement as it runs through the definition of member and as it runs through the other definitions that exist in the agreement, Your Honor. I don't think it's a failure to consider at that point in time when you have a board that says we're going to admit on varying only the price, and the impact of that is that they are admitted as members, Your Honor. And it's also not an appropriate time for implied covenant analysis, Your Honor, because 2011 was not a time of contracting at all. The members to the LLC agreement didn't enter into a new agreement. The members to the LLC agreement didn't negotiate a new agreement. They didn't enter into an amendment, and they didn't negotiate a new amendment. So there was no act of contracting at that point in time among the members, which is what is required to vary the 07 agreement, which is what the Vice Chancellor was purporting to do. The Vice Chancellor, in essence, created a hypothetical situation, a hypothetical 2011 amended LLC agreement, and into that amended hypothetical agreement, he implied a term that he created that was based on his view of what the negotiating history would have been at that time. And in that scenario, he revised the terms that are clear from the 2007 agreement, that is to strip away the rights of the members to the LLC agreement, Your Honor.
One thing I'm
Go
sorry.
ahead.
One thing I've been wondering about, and I don't know that you made this argument in your brief, is the Vice Chancellor found that Latches barred any claim that the new members were not properly admitted. Is there any disconnect in then using those same facts to imply a term of a contract?
Justice Valahora, there is a complete disconnect between that. The Vice Chancellor found that they were members. He gave them all the rights as members, the full panoply of rights. To Justice Seitz's question, he didn't then say, well, at that point in time, they changed the rights. He found that the impact of their membership, which the minority members challenged, was to have the full set of rights, including a 1.5 right. So, Your Honor, and we do make this argument that that fact, he dismissed the Latches argument. They have not appealed that argument. They are members. There is no agreement in 2011 in which you can imply a new term into this agreement. They are members. There is no gap.
And so, I'm sorry, just.
Just if I can follow up on that, you mentioned in response to Justice Seitz' question that the 2007 agreement established a process for the admission of new members. Doesn't the record suggest that that process was not followed?
I would respectfully disagree, Your Honor. There is, and if I use the word process, I didn't mean to. It gives the board discretion, gives the board authority to admit new members on the terms that the board determines. I think what Your Honor is referring to by process is this notion of preemptive rights. The preemptive rights issue has nothing to do with the admission of new members and the terms on which new members are admitted. Preemptive rights give the minority members or any other member the right to buy more units. The failure to adhere to the preemptive rights provision, and we submit that it was adhered to here, only gives a time-barred claim to buy more units. That's exactly the Chancery Court's conclusion in Gildor versus Optical, where the court found that there was a breach of the notice provision, and the right accorded to the non-breaching party was to buy more units. You can't, Your Honor, we would submit that you can't vary the rights of new members who paid $35 million for their units for some claimed breach of the preemptive notice provision.
I take it part of the thing is where you said the Latches comes together with this is your friends on the other side, client, assumed all along that these new members were members. They bargained for them to pay a higher entry price because the business had been successful. And that from the standpoint of implying something is if everyone assumed that these folks were members, if they didn't button up the formalities and you can't challenge it under Latches anymore, there's no gap, the thing. It's not as if one of these cases where everybody, there are alternative entity situations, you would agree, where somebody acquires equity without anybody knowing about it, and they might be an assignee, right?
Correct, Your Honor.
And in that situation, the formula wouldn't apply to an assignee. And if the rest of the members were then trying to force an exit sale, there might be a gap to figure out what do we do when there's this class of people who acquired equity. They're not actually a member. They're at a different tick rate because when they acquired the equity or something like that. But what you're saying is that just doesn't pertain here because however, whoever missed the formalities, it actually included their board representatives.
All three of them, Your Honor. All three of them.
And if Latches, if they can't complain about the status of these people as members under Latches, what is the gap?
Correct, Your Honor. They're members. They are and let's play out the rest of Your Honor's hypothetical. Okay, not only did they treat them that way at the time of admission, set a higher entry price, but then they treated them as members for the next 5 years.
No, that's what I'm saying. And so is it part of it, and in fairness to your friends, their primary how did this issue get injected into the case?
Your Honor, the Vice Chancellor raised it sua sponte at summary judgment. Okay, they
So
did not,
neither of the parties, in fairness to your friends, their argument was about the top off, about the other things. They never actually came up with this argument in the first instance.
That's right, Your Honor. They argued for leave behind. They argued for a completely different contractual interpretation all throughout the trial. On summary judgment, when the Vice Chancellor found that the highest amount theory was the only reasonable reading of the...
Are you arguing, are you arguing that this implied, the idea that these folks weren't, that there was some uncertainty about whether they were members in all respects, that this was are you arguing that it wasn't even fairly presented because your friends didn't present it in their post-trial briefs?
Yes, sir, we're arguing that nothing they're arguing here was fairly presented below.
Right, so that you didn't have a chance in your answering post-trial brief to even address these things, and then it manifested itself in the court's post-trial opinion as the primary reason why you lose, right?
That is exactly right. The Vice Chancellor found on the basis of an argument that the minority members never made post-trial. They abandoned it. They made it in a sentence in their pretrial brief, didn't make it in their post-trial brief.
A sentence?
One
in
sentence.
In the pretrial brief?
One sentence in the pretrial brief, not once referenced in the post-trial briefs, and that was the basis for the finding of the Vice Chancellor. And we would submit that that's exactly like the court's decision in Nationwide, where this court found that it was inappropriate to rule on the basis of an argument that was not made below against the party. Your Honors, I see that I'm running into my rebuttal time, so
Thank you.
Thank you, Your Honor.
Mr. Chief Justice and justices of this learned, esteemed court, I'm Michael Karlinski from Quinn Emanuel. I represent the appellee here. Before I go into what were my prepared remarks, I'd like to address some of the issues that came up, one by you, Justice Valera. With respect to the issue of laches, what's important to understand here is that what the court found was that the only notification that my clients received by virtue of receiving monthly statements was an identification of the two small holders as members. And that was the basis on which the court said, I am not going to allow you to challenge them as even being members. But it's a far cry from what didn't happen here, which is at no time, and this goes back to your question, Justice Seitz, at the time of the admission of these small holders, these two entities, the process was completely flawed from beginning to end. The court below, the trial court, attributed all of that fault to the Koch parties because none of the requirements in the LLC agreement were complied with. And in fact, as the court below
Wait a minute,
found...
But this is big boy law. I mean,
Yes, Your Honor.
we're not talking about people who, are doing consumer transactions here.
But, Your Honor, at the time of the admission, not only didn't the question get called, there was a process in the LLC agreement. There are two provisions of the LLC agreement that mandate that the terms and conditions of the admission must be announced, and then there's a process to be followed. Not only wasn't that followed, but as the court below found, the process was deliberately obscured by the Koch parties. And so to the question of laches, what the court below found was you received a notification that these two entities were members. But what you were
Didn't you also get a check for
1 minute.
a fair amount of money?
Yes.
Like how much?
I don't know what our proportional share was, but it was millions of dollars.
Was it over 10, 11
It
million?
might have been 10 or 11, yes.
And the other investor got a similar check?
Yes, Your Honor.
And you got that in part because you bargained to make sure that their entry fee reflected the success of the business in the interim from when you invested to when they got to invest?
Yes, Your Honor.
Right, so you focused on that, right?
Well, what we focused on, Your Honor, which was, let's go back to the trial court record. At the time of the admission of the small holders, there was no even announcement that these were the two entities. What the board was told as
May I ask you a
in the
question?
resolutions.
Let me ask you a question.
Yes, Your Honor.
You've now spent more time on this argument than you spent by far in the entirety of your pre- and post-trial briefs, correct?
No, Your Honor, I don't
Well,
believe
then
that.
explain that.
Okay, so on the
And,
question.
and in this, and explaining this, realize that several of us here all of us practiced in courts, and a couple of us were trial judges.
Yes.
And we take very seriously when excellent firms like you and the people you're affiliated with in Delaware write sections of briefs and head things with arguments. So your friend on the other side said that you had one sentence in your pretrial brief. I don't think you dispute the fact you had nothing in your post-trial briefs.
I do dispute that fact, Your Honor. and I'll
Okay,
cite
you
the
had
court
an
to the record.
argument section in your post-trial brief on this theory.
on the theory that...
The theory you want on.
Right, yes, Your Honor. So at the record at 635, which is where we have our pretrial brief, and then at page 703 of the record, we have the argument. It's a paragraph, but the argument about the faulty admission of the small holders is made. The post-trial brief, Your Honor, at page...
Did you argue that was the basis for
1505.
implied covenant relief?
I'm sorry, Your Honor?
Did you tie that to the implied covenant theory?
Well, yes, Your Honor. What we said was that at the time of admission, there was a complete failure to address the particular issues. And I even argued the issue at the closing argument. And so at pages of the record 1586, 1587, 1588, at closing argument, we addressed this issue. We said to the trial court that when you look at what was required, in fact, I cited the very provisions, you'll see that in the closing argument, we cited the very provisions of the LLC agreement which required that the question be called, which of course, as the court found below, that question was never called. The terms and conditions were never addressed. The board never had an opportunity. And just to go back to the Chief Justice's question, it is one thing we received payment, but as the court below found, the resolutions themselves, when these small holders were being admitted, referred to as stock, first of all. It didn't refer to LLCs, let alone controlled by Mr. Koch. The resolutions twice, in April and in November, refer to the issuance of stock to certain family members of Bill Koch and Sulphur Executive.
Did you believe, you knew it was family, like this is the season, all the stores tell you it's Family and Friends Day.
I'm sorry.
Family and Friends Day, like, you know, if you go in to buy a Ford, you get the same discount of a Ford dealership, you go into Macy's. No, seriously, I just want to know how many years ago your client supposedly fell off the turnip truck, that they assumed that these family and friends of Mr. Koch were not in fact family and friends, and that if there were entities used, they were not entities controlled by either Mr. Koch or affiliates of Mr. Koch.
Because it was never disclosed, Your Honor.
And you
in
didn't
fact-
care, right?
Well, we
And you
cared.
cared about getting the entry price,
We-
and you made sure you got the entry price. And you also, the record, and this is where the Vice Chancellor's in tension with himself, he says you all didn't care because you actually thought the business was thriving so much that the hurdle rates were never going to be a big deal.
Well, the court addressed that issue and factually found to the contrary. What the court found below was that, of course, we would have cared had the issue been presented, because there was, at that time, Your Honor, there was no 1.5 hurdle. Everyone who had been an original member had already received well in excess of 1.5. And what the Vice Chancellor found was that my clients would never have agreed, because the company did not need the capital.
Well, but no,
This was done-
he may be right about that. When you look back from 5 years, when you wish to force an exit sale, and when it turns out the business did not do as well as you had thought at the time, and when you're kicking yourself because you wanted the extra money and you got your $11 million, but now you think it's something much more than $11 million. When you look back, I mean, there's lots of times in life where, you know, you wish you had shot the ball instead of passed to a teammate or vice versa. Doesn't mean you weren't thinking at the time. It just means you didn't think well. And that doesn't mean that you have a gap because you get to do a do-over, right? And how can, I mean, if you can't challenge their status as members, and you can't deny to them the contractual rights they have under these exit sale provisions, how can the court then imply a gap and then basically ignore its own laches ruling and give your clients relief? I don't get it.
Because on the laches ruling again, the only thing that the court found, we had been told, Your Honor, was the existence of them as members. But that's a different question from what rights. And the agreement makes clear that the rights of new members...
Where did your client ever express, either of the two people in league, ever express the least bit of curiosity about, oh, these folks must have very different rights? It just must be. Someday we'll get to that, and we'll figure out what the family and friends' rights are. You never did that, right?
Because it was a non-issue.
Until it mattered to
No,
you.
until it mattered to the Koch parties, because the Koch parties then sought to take what was this faulty admission process, and when we exercised our exit sale rights, after 7 years of being an investor, we put our shares, Mr. Koch declined to accept them, we exercised our exit sale rights. That was the first time that Mr. Koch actually raised this highest price theory. And as the court below found, and the record is replete, Your Honor, for a year, the Koch parties all believed. We have their internal thinking because there was a waiver found below. We know what the Koch parties long believed. They had always believed that there was an ability to top off these small holders and allow an exit sale to go forward. And we have Mr. Koch's own words that this was the proper manner for the exit sale to go forward. No one had addressed, and therefore, as the court found, the gap was created in 2011 by virtue of the failure of the parties and really the obscurity by the Koch parties to call the question, to announce that, in fact, these were not going to be Mr. Koch's family members or some sulfur executives or a stock issuance, but rather what was never disclosed. And remember, Mr. Koch is a fiduciary. He has a duty to make disclosure here. None of that was disclosed.
Well, you
It was
also,
hidden
wait a minute,
from
your
us.
clients are actually on the board too, and also have a fiduciary duty to the people whose rights they're now seeking to deny after
Without
5 years
question.
of acquiescence in acknowledging that they had rights and after taking proceeds of their purchase, right?
And Your Honor, what the court below found was there was an unanticipated confluence of events. What was it? No one could have anticipated.
How does this add up to a gap? Because if you're
Well-
right about a top-off, you win. If they're right about the plain language of the agreement to live, but in neither case is there a gap unless you as fiduciaries are seeking to deny to members whose money you took the rights they have as a member, because when you never actually thought they had different rights.
Well, because, Your Honor, the gap is there was no process where any terms were conferred upon them. The agreement requires it. And all that the estoppel or the
So are you guys
point
giving
of-
the money back?
We would give the money back gladly. We've offered to top
Gladly
them
now,
up, Your Honor.
right? Mhm.
But
I'd
can
like to ask
can
you
I go
s-
back to the plain meaning for a moment, Your Honor? Because I do think the other way to get to the right conclusion here and the Vice Chancellor's conclusion is just on plain meaning.
Let me ask you a question
Yes, Your
on
Honor.
that, because this whole small holders' rights gap is not point one in your argument on your answering brief. It's this new plain language
May I address that?
argument. And how do you respond to your friend's assertion that, number one, this wasn't raised fairly presented below, and number two, not only that, it's contradictory to your own client's testimony who said, quote, "We did not have a top-off payment right."
Let me address both.
And three, that it conflicts with your implied covenant top-off gap theory.
First, let me deal with the fairly presented point. Your Honor, the court below at summary judgment specifically addressed what it referred to as my client's, the minority member's argument that there could be under plain meaning, there could be a top-off payment. Now, the court at summary judgment addressed that, and as this court has held, even where a court below sua sponte raises an issue, it's preserved and it's considered fairly presented. But here, the court below didn't address this sua sponte. It addressed this issue because as it found that in the pre-litigation lead-up to the filing of this case, the minority members had raised the plain meaning argument, and the Koch parties, when they filed suit, they put this at issue in their complaint, and ultimately it was raised and argued at summary judgment. That's why in the summary judgment opinions at paragraphs 14 and 15, the court refers to the minority members having raised this argument in pre-litigation correspondence, and then it having been raised at summary judgment. Now, I raise that because what then happened, so we made the plain meaning top-off argument in correspondence. The Koch parties then inject it into their complaint, and it's raised at summary judgment. The Vice Chancellor then ruled against us on that issue squarely and said that the highest price theory is the correct interpretation. At that point, but left open the very question of the implied covenant. So we were channeled into the lane of the implied covenant, which is where we continue to litigate the case. With respect, it would have been a fool's errand to try to convince the Vice Chancellor, in light of his plain meaning argument, that he should still accept our plain meaning top-off argument. But it was raised below, and as this court in Lawson and in Hokessen, I think I pronounced that right, Your Honor?
Hokessen. It's good. I'm giving you props.
I wanted to make sure.
I listened also this fall to my son being introduced on a field, and they kept saying Hackeson or Hawkison, all kinds of things. So Hokessen, yeah.
So it was preserved from a fairly presented standpoint. Then what I also want to make clear, this I think goes to Your Honor's second question. When you look at the implied covenant arguments that were made below, one was that there was an implied covenant that just simply allowed a top-off even if the smallholders were members. As my esteemed colleague points out, both sides were heard on this issue below, and the court obviously wrote an opinion on it. So from the standpoint of fairly presented, this court, as a reviewing court, has the benefit of the lower court's thinking on this. But now to the second point, the implied covenant argument that we made below was, first, you can have a top-off through the implied covenant. We made that argument because we were channeled into that lane, with His Honor having ruled against us on plain meaning. But when you think about what our implied covenant top-off argument was below, it's a virtual identical argument to the plain meaning argument that we had initially made and that we raise here on appeal. We said below, and the Koch parties at page 6 of their reply brief concede this, below, as a plain meaning argument, we argued that the LLC agreement does not prohibit a top-off. Their words. They say that below, we didn't explicitly argue that it permits a top-off. And that is partially true. Below, we first raised the argument. The Vice Chancellor ruled against us on it being permitted under the agreement. And so we were channeled into this implied covenant lane. But the plain meaning argument that we advance here, Your Honor, is a virtual overlap to what we did argue below when we said it's not prohibited. The only thing we couldn't continue to argue in front of the Vice Chancellor in light of his ruling was that it was explicitly permitted. And what we actually said below was the word top-off does not appear in the LLC agreement. And that's true. But our plain meaning argument, the first argument that was raised in the correspondence that even preceded this litigation, is a virtual overlap with the argument we make here on plain meaning. So it was preserved. We're talking about the exact same provisions. When we argued below that the LLC agreement did not prohibit, we focused on 7C, 7D, and 9B.
I've never understood. Can I ask a question about the substance of Justice Alhero, just one about your argument? I get how everybody would think that, or they'd want to top off. I never have understood how it fits within the contractual language, because I don't understand why anybody has an obligation to accept it. And I don't understand what the top off payment, what transaction it's part of. Because if it's part of the exit sale, then it's supposed to come from the buyer and be part of the consideration. If it's to use a Louisiana phrase, if it's a lagniappe added from another member in order to force the exit sale, wherein does the contract provide how that's supposed to happen? Why? And what you're trying to argue is that somehow you have everybody has the duty to kind of comply with and aid the effectuation of a complying exit sale, right?
That is one of our arguments, yes.
Yes, but then the exit sale consideration doesn't include the top-off, but you have a duty to accept the top-off to facilitate an exit sale. And it also, if people wanted to do this, wouldn't they say, do the equal consideration thing and say, provided, however, that if a member who wishes to force an exit sale wishes to take some of the consideration that they receive to satisfy someone else's hurdle rate, then they're able to do that and force an exit sale. That would seem like something you could scriven.
Yes. And the way they articulate it, Your Honor, is by using the phrase resulting proceeds.
Proceeds from what?
Well, it resulting proceeds from an exit sale. So when my clients take chips from their pile of the exit sale proceeds and move them over, those are resulting proceeds. They're proceeds resulting from an exit sale. And if I can just make, to answer Your Honor's question, what my friends say is that resulting proceeds must mean the direct payment from the buyer to the seller. But of course, it doesn't say that. It says resulting proceeds, proceeds resulting from an exit sale. And if the parties intended for it to be a direct payment, they could have said it. And they did say it in other contexts. What I would ask the court, I would refer the court, in the earlier portion of Section 80, 80 is the provision that says specifically,
Why do friends and family have to accept diverted consideration?
three answers, Your Honor. First of all, it's resulting proceeds. Second of all, it says.
But it's not the way the offer is structured. Those proceeds went to your clients.
And what it does is it
By the way, when this
satisfies-
offer was put on the table, it didn't have a top-off, it didn't have all this intricacy in it, right?
No, the offer from the buyer was an
Right.
offer. And then we, at one point, proposed a top-off payment. Now, Your Honor, just to answer the question, it uses the term resulting proceeds. In the very prior portion of the same sentence, where it talks about payment of the fair market value, it uses the phrase aggregate
Right.
consideration. And in 7C and 7D, it refers to aggregate consideration. The exact language is, based on aggregate consideration received by such member in respect of the units transferred. That is a clear articulation when it's referring, we all know what consideration means. It's the quid pro quo in a transaction. So when the parties wanted to make clear that there were monies that had to come directly from the buyer to the seller.
Yeah, I give
they
you,
used
I
that
gi- I give you
articulation.
credit for giving these parties credits for understanding at all what they were doing. I think the one thing is probably clear, that none of them really understood what they were doing, and they were doing a form. Is there a definition of proceeds that helps you?
There's not, it's an
Yeah.
undefined term, but aggregate consideration is
And why do
used
we think it
different.
means something different?
But, Your Honor, I mean, just if you look at the fundamental purpose of the 1.5 clause, the 1.5 clause is to provide compensation. It's compensatory. That is the one thing in the case that all parties agreed upon.
Can I ask a question just
Yes,
so,
Your
I mean, sometimes it nags at human beings when they're doing something and there's a curiosity that emerges. Were your clients, was partners in the buyer? Which is, were they intending to have an ongoing equity interest in the buyer?
That was
In
under dis-
in the company once they
That
was acquired?
That was under discussion.
And so, under discussion, because that just blows, that just makes entirely irrelevant all this really intricate stuff that you put in everybody's put in everybody's head at holiday time, right? That's clearly not okay in terms of that, without offering the same terms to Mr. Koch and the other members.
And I don't know that the record addresses that issue. I don't think
No,
that
no,
issue.
I mean,
I don't,
what I
Your Honor,
mean
that
is
was
that-
never
no,
raised.
I mean, I understand that.
was
I'm
never
just
raised.
asking, Matt, you've been candid. This was going to be probably like a private equity play, but the other members were not going to receive an opportunity to roll into that structure. Your client and its colleague fund would, right?
It was under discussion, but the argument that Your Honor is raising was never raised below.
Well, okay.
And it certainly was not addressed by the Vice Chancellor in the opinion. And I just want to make sure I come back to the last question of Your Honor, Justice Valahora. You asked, isn't our argument inconsistent? Hopefully from the prior answer, I've explained. It's completely consistent. The plain meaning argument that we've advanced here is consistent with the argument we've made below. The implied covenant argument and the implied covenant ruling that His Honor below, Vice Chancellor found, is also consistent. Because
Let me
what
ask you one more question before
Yes,
your
please.
time runs out on that. Would you agree that if we were to view the time of contracting as 2007 instead of 2011, you have a very difficult time on the implied covenant, given the testimony on the other side that a top-off would have been a deal killer?
Well, if I can answer the question by saying the court below expressly found that the time of contracting here was 2011. That's
Well,
verbatim.
if we find that to be error,
Well,
is my question.
Well, I think if you find it to be clear error, then I think that could be a problem. Although, remember, in 2007, Your Honor, the parties left open what the court below found, referred to as an intentional gap, left open for future
But
determination.
isn't that sort of oxymoronic to say there's an intentional gap if the
It
implied
was,
covenant?
it was the court below's way of talking about the provision allowing in the future for the determination to be made at the time of the admission of new members, which makes sense. Because until you're admitting new members, you don't know when, you don't know who they are, you don't know the facts and the circumstances, you don't know what capital contributions they're going to make. So when the court refers to intentional gap, it's just talking about how in 2007, that question was left open for future reference. To the factual question Your Honor puts, which is Mr. Koch's testimony in 2007 that he wouldn't have agreed to a top-off, as the court below correctly found, that doesn't look at from the right time frame. It's 2011. Of course it's a time of contracting. How else does my friend stand up and say that these small holders have contractual rights? They can only have contractual rights if in 2011 that was a time of contracting, an act of contracting. There was to be an amendment to the LLC agreement. And so when we look at, I'm sorry.
I believe Justice Valor is satisfied with your
Yeah,
answer.
thank
And
you.
I think you, counsel, you've done an excellent job answering our questions. We'll take the matter under advisement and we,
He's got,
oh, you,
I do have a question.
Yes, Justice.
okay. Sorry.
And you do have time left, I believe.
I do, but it's...
And by the way, red and green are very seasonal colors.
With respect to your argument of waiver
Yes, Ron.
on the issue of whether the failure to set terms and conditions in 2011
Yes, Ron.
created a gap,
Yes.
that argument's been waived. But this sort of the factual predicate, as I understand it, of that argument was made below. It was just done in the context of whether the smallholders' admission was done properly.
That's exactly right, Your Honor.
So what, my question is, what is it that you didn't get to present or argue in the court below by virtue of the change in the,
Your Honor,
tenor.
Rule 8 is a function on fair presentation on their part. They didn't make that argument. We didn't get to counter that legal argument because they never dealt with and present facts concerning that legal argument because they never made the argument. This is what they said in their pretrial brief, Your Honor, A8671. Here, the LLC agreement contains a gap because it does not explicitly permit or prohibit a top-up payment to a particular member to satisfy 1.5x clause. That's the pretrial brief. Post-trial brief, A1477. The agreement contains a gap because the exit sale provisions do not expressly permit or prohibit a top-up. This issue only came up because we were arguing that there was no gap in the 07.
So what you're saying is that is not an argument that relates to whether when the Friends and Family came in, they had the full rights as other members. It's simply an argument about the facilitation that a member has to do if it's offered a top-up.
That's exactly right. And to Your Honor's point, to the Chief Justice's point, the record is undisputed. The evidence is undisputed that the Crestview parties were going to roll into the ArcLight transaction. That's the opinion at 90.
Why didn't you just simply argue, like, hey, that's not the same terms, and duh, that doesn't qualify?
We made that argument below, Your Honor.
It just wasn't considered?
Correct. It was not addressed. I think the Vice Chancellor, as I recall it, rejected that argument. But we certainly made the argument that the ArcLight offer failed the all securities requirement, which requires that a transaction be on all but not less than all, and the like. So,
Well, no, but that's a different thing. being able to roll is different than all but all, because sometimes you can,
Correct.
they can play games. I mean,
But they
I
can't
didn't
do
mean that
that.
in a bad way. I love games. You can figure out a way for it to get substituted.
Completely agree, but any way they get around that, it still can't be all but not less than all. We would have argued that they have.
They had to make the same terms available for.
It's both,
okay.
Your Honor. It's same terms and conditions and all but not less than all. And on this point that my friend has raised about the notion that there was some fiduciary breach by Mr. Koch, they brought a breach of fiduciary duty claim. They dismissed that claim with prejudice in the middle of trial. They were on the same board that Mr. Koch was on. There were no fiduciary duty claims. Fiduciary duties had nothing to do with this. Thank you, Your Honors. Have a
Thank
happy
you,
holiday.
Counsel. Happy holidays to everyone.
Thank you.
Please rise. Hear ye, hear ye, hear ye. All manner of persons having anything before the Supreme Court of the State of Delaware may now depart and give their attendance to the call of the court. The court is now adjourned. God save the state and the honorable court.